Thank you. We've reviewed it. Looks like there are a number of varied issues.
There continue to be a number of issues, Your Honor, and we appreciate the opportunity to come in every week like this. I want you to please be aware that the city does, in our private partner resources, and the city do have shelter beds available for anybody in the encampment that want to avail themselves of it. And we have our housing ombudsman, Joe McDowell, our neighborhood, our human relations and community resources department was happy to help any of these individuals. We've actually had people coming to these every week to these hearings to provide those resources, and we'll continue to do so. We would just like to get this nuisance abated and move get this encampment, which I know you do.
Totally agree. So tell me, and sorry to interrupt you, but tell me how many beds are available, and can we immediately move people there?
It's a moving target, Your Honor, especially now because the winter is coming. It makes it tough, it stretches our resources, but we do have beds available. It fluctuates day to day, but for people that want to avail themselves of proper shelter, that we do have availability. My housing ombudsman told me that, and this is anecdotal, so I mean, this is not firsthand, but that Susan Kangaroo at the Advent House is going to have 11 openings online that they can work to move people into. So, and that's a little bit more than transitional shelter housing. That's a little more substantial. So these things are, and I know beds open up, especially January 1st, but in the month of December as well, beyond what are open now available. So we do have somewhat of a safety net for people to get in out of the winter.
So how many people are left there? I mean, you've addressed about 50 people here, so how many are left?
To our knowledge, that's about the amount of people. These are people that have come forward and actually made contact with the city. So there's still an unknown there.
And these beds that you're talking about, are they available for a night or two or longer?
Some are more transitional, short-term shelter beds. Others are, when I was indicating the Susan Kangaroo, those would be longer term.
Okay, so the next question is, you said those longer term beds are available online?
Through the Advent House. They have their own procedure. They're a private operation.
But people who are homeless don't have computers, so how do we get them connected with the Advent House? Is the Advent House going out to the camp or what?
I think there are all kinds of ways for people to contact Advent House without having to use a computer. They are located locally. They are listed. If anybody has trouble contacting, they can go to the 4th floor of City Hall, and our Human Relations and Community Resources Department will put them in contact.
Okay, so is there anybody here who wants to avail themselves of the Advent House beds? I don't see any hands being raised. Okay, well, spread the word. That seems like a longer term solution. If there's 11 beds, that's 11 people who are out from the cold. That's a lot.
We agree, Your Honor.
And what about the people who want to remain outside? What are we doing there? Because they then need to be moved to a state facility. A state park facility, I should say.
Your Honor, the only thing we have the ability to do is to ask this court to abate the nuisance. And by that, we would ask the owner of the property, the private property, to clean up. If they won't do it with this court's order, we will clean it up. We will provide shelter to the people that are on the premises when we move in to clean it up. Because that's what, when we have an encampment in our parks, we make sure there are beds available for everyone when we go in and clean that up, because we have to preserve the right of ways. This is the same procedure we would do here. And now we're planning on with your 90-day extension. That's our hard date. So we're happy to work with people. We're happy to find them homes as long as the court, but at some point we would like to have the ability to abate the nuisance.
I agree. I need those people in the encampment to be willing to move off, so you're not forced off. And if there are beds available, there should be hands going up saying, I want a bed. And then to continue to work with the city to have a more permanent solution. This can't go on forever. I'd like to say I could give everybody a house, but I'm not Oprah. So I don't know what else to do except utilize the services that are available. Because the property does have to be cleared, and this is a nuisance. It's actually dangerous with the propane. And there have been fires, I've seen the burned out shelves. I'm happy to go there again, but it's really a taking of someone's property. We can't do that. But as I've indicated many times, we also can't abate it in a couple of days when it's gone on for 3 years. I'd like to find permanent solutions, so you're not back here with your case. And it sounds to me like you're getting more of a permanent solution, at least so people can stabilize themselves and then move on to their own housing, employment, etc.
And just anecdotally as well, Your Honor, so that you know, we had a hand washing station on the premises. The company is unable to winterize that, so they retrieved the hand washing station. But we have had water taken to the premise, and I believe it's just been delivered recently. Again, I don't know this at personal knowledge, but that's my understanding. And finally, it's my understanding that the dumpsters have been at least emptied and are brought back onto the premises, so.
Is there any portion that you can start to clean where people have moved?
Bulldozing is not a scalpel. So once you start doing stuff like that, it's disruptive, and it's hard to move portions of people away from an area. If we could, as with our parks and encampments, if we could move them all into good shelter, then clean the encampment, it's just better for all involved.
What, if anything, can I do to help this process?
First, as you're aware, we filed an objection to your order, and I think we need to have, because council isn't showing up for any of these, so we need to have a hearing date so that they can.
I believe we found a hearing date.
And we do have a notice of hearing to provide them, so which hearing date?
December 3rd at 1?
December 3rd?
At 1, is that soon enough for you?
That's fine. And then,
December 3rd.
December 3rd at 1.
And then that's all the business we have for you today.
Okay,
However, we would like I mean, we're happy to bring water. We would like people to drink.
Good to know.
Thank you.
All right. Well, then let's get to serving those people and getting more services and beds. Let me know if I can help. Thank you.
We'll see you next week.
See you next week. Well, no, next week is, oh no, are we here next Wednesday?
No.
No, we're not here next Wednesday. So the next time I will see you is December 3rd for that motion.
Thank
We've
you.
got the holiday coming up. Thank you.
Happy Thanksgiving.
Happy Thanksgiving.
Oh, he's not doing this line.
I don't know what we're doing next.
There we go.
Well, they're gonna go down the hall, aren't they?
1:30 is Steve Bradley.
Oh, wait, well, copy, we copy.
Yeah.
Oh, that's what we're doing next.
That's next. It's just a lot of papers.
I don't remember going over it. Okay. All right, this is docket 24412 NI, Stephanie Lavelle, personal representative of the estate of Bradley Lavelle versus Michael Patrick Mullen, Ryder Truck Rental Inc. and Ryder Integrated Logistics Inc. Counsel, your appearances for the record.
Good afternoon.
How
Good
are you?
afternoon, Your Honor. Sean McNally appearing on behalf of the plaintiff.
Don Wingham appearing on behalf of the defendant.
Thank you. And this is defendant's motion for spoliation of evidence, is that correct?
Yes, Your Honor.
All right, you may proceed.
This is our motion in limine for plaintiff spoliation of evidence. This involves a fatal motorcycle accident that occurred on October 24th of 2023. Our motion seeks admission of evidence of the disposal or loss of the decedent's motorcycle, and that the jury instruction 6.01 be submitted to the
And
jury
what?
at trial.
I'm sorry.
Oh, I'm sorry, for today.
For the loss of the student's
Motorcycle.
motorcycle, and I move it.
And that jury instruction 6.01 be submitted to the jury at trial. Now, the dispositive facts here, I believe, are completely undisputed. The motorcycle accident itself, as I said, took place on October 24th, 2023. Plaintiff's decedent passed away that same day. When he died, the motorcycle became property of the estate. Now, the plaintiff in this matter, Stephanie Lavelle, was appointed personal representative of the estate on November 15th, 2023, which was about 3 weeks after the accident. At that point, the motorcycle is property of the estate, and the plaintiff is the administrator of the estate, personal representative of the estate. Now, on November 17th, 2023, 2 days later, we sent a letter requesting that this evidence be preserved, specifically the motorcycle. And plaintiff took no steps whatsoever to preserve the evidence. The motorcycle was the property of the estate, and it was under the possession of the police department as part of an investigation, but it was the estate's property. And in response to our motion, plaintiff argues, well, we didn't know. We don't know where this thing is. We don't have it. We never had it. I never had it. I never saw it again. We don't know what happened to it. And the affidavit, and it goes on and on about all these things that they don't know, but they don't ever discuss what they did affirmatively to preserve the motorcycle. They had an obligation to preserve this motorcycle. And to come before this court and say, we don't know anything that happened. We don't know where it is. We don't know. We never got any keys for it. We never got paid for it. We never saw a title for it. That's not the defendant's issue. As the personal representative of the estate, they have the obligation to preserve evidence that is the property of the estate. It's undisputed that this motorcycle was the property of this estate. It's undisputed that they had an obligation to preserve this evidence. They want to come in and say, well, we don't know what happened to it. Okay, it's lost. They took no affirmative steps to preserve this motorcycle. They were on notice 2 days after the plaintiff in this case was named personal representative. So as the personal representative of the estate, the plaintiff had the right to possession of the motorcycle. They had the right to possess the motorcycle. Just because they didn't exercise that right in furtherance of their obligation to protect the evidence, plaintiff allowed property of the estate to be lost. And whether that happened negligently or intentionally doesn't matter. They had an obligation to preserve property of the estate. They did not take any steps to preserve property of the estate as evidence. So at this point, defendant has been prejudiced by our inability to look at this motorcycle, test the black box, to look at property damage, to determine speed, things like this. We don't have that opportunity because the plaintiff, as personal representative of the estate, failed to do anything to preserve the estate or preserve the evidence. Or
Did law enforcement take custody of the vehicle?
yes,
And wasn't it their responsibility then to release it to its owner?
perhaps.
Okay.
But if the plaintiff herself, she's the administrator of the estate, she's the personal representative of the estate. She has, and the motorcycle itself, possessed by the cops or not, like that motorcycle is property of the estate.
It may very well be, but have you contacted the police to see where it is? Because I see them confiscate a lot of things, and oftentimes it takes a court order that I have to produce to order them to give back the phone, the whatever was seized, because the case is over and they're done with it. There's no longer a pending case. So was any of that done?
Well, I appreciate that, Your Honor. And what I would say is that would be for the plaintiff as the personal representative of the estate to call the police department and say, where is my motorcycle? Where's the property of the estate that I'm administering? Where's my property? Me as a defendant, I don't have any right to that property. I can't call the police and say, give me this. It's not mine. The affidavit goes through and says, 38 things that we didn't know, we didn't do, we didn't see, we didn't hear, but it doesn't say any one particular thing of what they actually did to preserve this motorcycle, because they did nothing. Thank you.
Thank you. Ms. McNally.
Just very briefly, Your Honor, the three elements of spoliation are control. We never had control of it because the police did. Lacking a reasonable excuse for failure to produce the evidence is a second, and there is a reasonable excuse. She never had it. Stephanie never had it. The mother never had it, who was also not the personal representative. And that it's material. We do agree that it could potentially be a material fact, but one thing I do want to correct is that Stephanie LaBelle was not appointed personal representative until January. So they say 3 weeks after the accident, which was October 24 of 2023. She wasn't appointed until January 4th of 2024. And I think Your Honor already touched on this. We don't even know that it's unavailable because they haven't sent a subpoena to the police department. They haven't done anything to attempt to find the vehicle. We have the photographs, and that makes the vehicle cumulative evidence essentially. I mean, there's nothing on this vehicle that can be taken off of it that will change any fact in this case, because it is known that this type of motorcycle, or many motorcycles like this, can't get downloaded as a truck can or a car can. And that's why there hasn't been an inspection in the past at the beginning of this case. Just two very brief points about the reply brief. We objected to it because it's not a motion for summary disposition, therefore it was improper. And second, that it did bring up
Oh, I'm sorry, hold on a second. It did what?
it did bring up the new argument that there was a some type of reasonableness argument, which is again not a portion of the elements of the spoliation claim. So in its whole, plaintiff has done what we can. If we had the motorcycle, we would certainly produce that, but
Can you, I'm sorry to interrupt counsel, but can you request, or would you all like me to order the police to turn it over if they in fact have it? Do we know if they have it or not? And shouldn't your client request the motorcycle back? Unless it's part of an ongoing investigation, it should be turned back.
I mean, I guess the answer to that, I don't know the answer to that. We haven't requested at this point. We try to get a hold of the police to see if that's a possibility, and sure, if the court would order that, I don't think we certainly wouldn't object to that, let's put it that way.
Which police department is it? Do you
It's
know?
Lansing.
LB?
Yes.
Okay.
And that's essentially it. The only other thing is that we are requesting an order that that jury instruction not be used at trial, because we've done nothing wrong here, in order that no inferences or arguments regarding plaintiff spoliation, because they had the same opportunity to get this vehicle as well, or get it inspected as well, because it was right in the police report from the beginning. We put this into impound. That's right in their motion, stating that it had gone into a specific impound. So if they wanted to go and inspect that vehicle, that was certainly within their rights. It's something that they had from the beginning.
Thank you. Response?
Here, briefly, I took the November 15th appointment date from the affidavit, so that's my mistake if that's in there. But plaintiff's attorney said a lot of things, but he didn't say anything that they actually did to preserve this evidence. They didn't do anything. They sat on their hands and wasted, or just let this piece of the property of the estate sit wherever it sat. And this is 2 years now. They were on notice in November of 2023 to preserve this. They took no steps to preserve it. They never called the police department and said, hey, where's my motorcycle? Is a motorcycle that's worth $5 or so grand?
How long have you been asking for the motorcycle?
We asked for it to be preserved
Yes.
2 years
when?
ago. This was
And-
November 17th, 2023.
And if they didn't comply, the court hasn't moved in the last 2 years. Why haven't you asked the judge for help?
I can't answer that, Your Honor.
Well, you're asking them to answer some questions. So that's the one I tossed back to you. Here's what we're gonna do.
Sure.
I'm not going to allow you at this point to use the spoliation. We are going to, by order of the court, which my law clerk and I will draft quickly, it's not going to be a very long order, ask LPD to produce the motorcycle, and if it's still under investigation, to allow both of you to go wherever they're storing it, to view it, test it, do whatever you need to do, or to turn it over to the estate. The estate will then be ordered to preserve it, and you all can test it, review it, whatever it is you need to do. If it's not there, then apparently no one knows where it is. And if I use reasonableness as the test here, I don't know how reasonable it is for a grieving person who is the personal representative ultimately months later to think, oh, I need to preserve that for trial. I would think that it is in the best interest of plaintiff to have the motorcycle, because there may be more parties at fault once you investigate that. So I don't think it was intentional. However, I've dealt with the police departments in this county for long enough to know they hang on to all sorts of crap. They don't even know what they have. Sometimes law enforcement keeps evidence in the trunk of their vehicle and they drive around it for years until, oops, we're going to trial. Where is it? Oh, I forgot to log it in. So I don't know whose fault it is, and I'm not going to assign blame. I'm going to use the rule of reasonableness, which is for the court to first ask law enforcement, where is it? For all I know, they disposed of it. I really don't know, and neither do both of you. So let's start with reasonableness. That's my order for today. Is there anything else I can help you with today?
No, Your Honor, there is one more motion.
I would just add, in as much as will the order that the court enters deny our motion without prejudice?
Yes, it's without prejudice.
Thank you.
I don't like to do many motions with prejudice because I was a lawyer long enough to know that things change. And I'm a patient enough judge usually to re-listen to motions when there's more information. But quite honestly, this motion is 2 years late. I don't know where it is. Neither side has done the discovery or the request of law enforcement, so now I'm gonna do it. So what's your other issue?
Oh, no other issue. We just have another
Okay.
motion pending on this matter.
Okay, then let's move on to that. And counsel,
Oh, it's not my motion.
is this the motion for temporary admittance?
Oh, yes. It's for this motion. Moving for this. Oh, is it? Okay.
Under Pro Hac Vicis, as long as he's paid his fee, we're good.
Right, this is Mr. Britton, I believe, and we're moving forward temporary admission to the Michigan Bar. Should the court rules.
Any objection?
No, Your Honor.
So ordered, as long as you pay the fee, you're good. And I think that I have, I thought I received notice, but I don't know where it is in this huge file, but as long as he's paid the fee, that is not an issue. If you'd like me to sign the order, I'm happy to do that.
Yes, Your Honor, I believe we paid the fee, and thank you for letting me appear by Zoom.
No problem. I thought I saw that come through some time ago, so I'm
Yeah.
happy to sign it. Mhm. And welcome. Court has signed the order and you'll each receive a copy. Is there anything else I can do for you?
No, thank you, Your Honor. Have a great day.
You too. See the order.
Yeah, I wrote it down.
Defendant for,
Oh, did you just want to check?
yeah, so it's the
Yeah.
Tabitha Williams versus Carolina Apartments, 42 North.
Versus the next
I am here for Carolina Apartments,
Not till 2.
Justin Gonzalez.
Next is not till 2.
What is it?
Supposed to be terminated in receivership.
Yeah, like plenty of time for that, right?
Is everybody here on the receivership?
I think it's just me.
Okay, well, we all were about 12 minutes early, which is unusual, but can we do that?
I'm ready.
My client may be having someone attend by Zoom, but I don't think they'll mind if we go early.
All right,
I'm here, Aaron.
Oh, there he is.
all right, very good.
Hold on. Which one are we doing?
This is docket 15.
Which one are we doing?
We're doing the, you in which case, the leadership vice director and the petition. Is that to apply?
Consumers Mutual. Leah Fox, Director of the Department of Insurance and Financial Services.
Right, I'm pretty sorry.
Okay, this is docket 15-948 CR. NRA petition to reopen Anita G. Fox, Director of the Department of Insurance and Financial Services versus Consumers Mutual Insurance of Michigan. And it's the receiver's verified motion to terminate the reopened receivership. Counsel, your appearances for the record.
Thank you, Your Honor. Assistant Attorney General Aaron Levin here on behalf of the Director in the Department. And by Zoom is the Director of Receivership, Thomas Mitchell.
All right, thank you. And is there anything you'd like to say for the record?
But Your Honor, we submitted everything in writing, but by way of summary, this matter was reopened because the department received money to be distributed to creditors that it was not expecting at the time the receivership was closed. It has completed making those distributions, and we would like to terminate the receivership and close the file.
And there's no one here to object, is that correct?
That's my understanding.
Do you have an order?
I do.
You may approach.
Thank you.
Thank you. Two, take one.
Thank you very
We'll
much.
get this file. Is there anything else for the record?
No, thank you.
All right. Thank you. That is all for the record. Anything else? Anybody?
The next one is just right next to the list, the top fields 9.
I don't know where my list is.
Huh?
Which one are we doing?
Which one is it?
I don't have a list, so I don't know.
Okay.
Carolina Apartments. That's 2, so I don't know for this year.
Is everybody here on the Carolina Apartments case?
Yes.
I believe so, Your Honor.
Well, we're running a few minutes ahead, so thank you. All right, this is Tabitha Williams versus Carolina Apartments LLC and 42 North Outdoor Services LLC. Docket 254419 and O. Counsel, your appearances for the record.
Yes, Michael Laurel for the plaintiff.
Good afternoon, Your Honor. David Nelson for the defendant, 42 North.
Your Honor, Justin Gonzalez on behalf of Carolina Apartments LLC.
And who is seated with you?
This is Myra Fairfield. She's a brand new attorney with our office, just here to observe.
Welcome. Thank you. Yeah, all right. So this is defendant's motion for summary disposition, correct?
Correct.
You may proceed.
Thank you, Your Honor. Yeah, this is defendant's motion for summary disposition under C8. The primary basis is under the Foltz decision that as a contractor, they're not liable unless there is some separate duty that is separate and distinct from the contractual obligations. the plaintiff has alleged basically two theories of liability of defense defendant, one against defendant. One is negligence, the other is premises liability. I'll address those each in turn, but for the reasons just stated, the negligence claim fails because there has been no allegation of any separate and distinct legal duty apart from the contract, therefore under fault summary disposition is required. As to the premises liability claim, the plaintiff hasn't alleged any actual facts establishing that the defendant, who's a contractor, had actual possession of the property at issue, which is necessary for a premises liability claim to lie. And it's essentially contrary to the nature of a landlord that a snowplow company would actually have possession of their property on the day in question. Now, as this is a C8 motion, we have to look to the allegations of the complaint, as well as any contracts that formed part of the pleadings, which the snowplow contract does form a part of the pleadings, because that was in the cross claim by the defendant, Carolina Apartments. If we look at the allegations, so paragraph 1 of the complaint alleges unsalted ice, that she fell on unsalted ice. Paragraph 11 states that she fell on a large patch of unsalted ice. If we look at paragraph 12 of the complaint, it states the common area of the apartment complex was not salted or de-iced in any capacity. If you look at paragraph 19, the allegation is defendants did not make any attempts to salt and or de-ice portions of this frequently used common area.
Wait.
Sorry, I'm going a little.
No, my computer I must have hit like a weird button. If you look at paragraph 19, the allegation is.
Defendants did not make any attempts to salt and or de-ice portions of this frequently used common area. And then clearly in an attempt to get around the separate and distinct requirement, plaintiffs allege generally that the defendant undertook the task of maintaining the sidewalks and parking lot and removing snow and ice hazards. This is essentially simply a restatement of what the contractual obligations are, that they had a duty under the contract to remove snow and ice. However, as is illustrated from the contract, they really had no duty to salt unless it was actually approved by Carolina Apartments. So that duty was contingent on Carolina actually granting approval. And then if you look at paragraph 54 of the complaint, where it lists all the alleged breaches, it's notable because it does not establish any affirmative act that defendant undertook in the performance of its contractual obligations. It simply says failing to inspect, failing to remove. There was no affirmative act that was actually alleged. This falls squarely within the false decision. The false case, in that case, it was a snow removal contractor, just like you have here. And the claim was that the contractor failed to remove snow and ice. The court stated that the contractor only owes a duty to third parties in negligence claims that are separate and distinct. Failure to perform contractual duties is not a sufficient basis for negligence. And false was distinguished the Osmond case, which was one of the cases that preceded false, which actually did find a duty on the part of the contractor, because in that case, the contractor engaged in its duties under the contract, but did it negligently. They essentially pushed snow in a location that was unreasonable, which caused the plaintiff to trip and fall in that case, which is clearly a distinct type of claim. Then you turn to Lewecki, which is the case that did not overrule false. So it should be clear that it didn't overrule false. It also didn't overrule the separate and distinct analysis that false used. What it did was it clarified that analysis to a certain extent. It said that just because you have a contract doesn't mean you get rid of all the common law obligations. But what it did say is that it required some action on the part of the contractor in the performance of their duties, and then they have to do it negligently. Here, there was no action in the performance of the contractor's duties because they weren't asked to salt on the day in question. So there was no allegation that they actually were performing their duties on the date that this incident occurred, sufficient to trigger the Lewecki line of cases. In Lewecki, it's also clear that it's factually dissimilar from false, because there you had a contractor who actually placed a board in a position that was unreasonable the board fell on the plaintiff. That's again similar to the Osmond situation where a contractor plows in a manner that's unreasonable. In that case, the court said there was a question of as a fact as to duty, which a duty typically is a question of law for the court. But in that case, they said, well, because of the way these boards were placed, that there was likely a duty separate and distinct from the contract. And then you look at all the post-Loecki decisions, which tried to clarify this kind of distinction. And I'm not going to go through all those cases because I cited a litany in my brief, but in all those cases where courts found a duty separate and distinct from the contract, it all existed a situation where the contractor actually performed the duty or an obligation under the contract, but created a new risk of harm in doing that. And that's consistent with the Osmond line of cases. Now, plaintiff has cited a Sixth Circuit case from the Sixth Circuit Court of Appeals, Leon. Obviously, Sixth Circuit interpretations of Michigan law are not binding, but addressing that case, that's factually dissimilar from the allegations here, because in that case, the contractor was specifically hired to inspect property and remove debris, such as loose slag from a certain area. That was part of their duties under the contracts. They inspected this piece of property, but they didn't find any loose slag. So the allegation was that their negligent inspection, part of their contract, was what was the basis for negligence. Here, there's no allegation that the defendant went out to the site on the day of the incident and inspected it and saw that it needed to be salted and said, oh, let's just not salt. There's no allegation to that effect. So really the Leon case is distinguishable. This case falls squarely within the Faults decision. And as a matter of law, under Faults, defendant's entitled to summary disposition as to the negligence claim. Now, if we turn to the premises liability claim, that's contingent on possession. There's no facts establishing that 42 North had actual possession of the premises. That's not alleged on 12/21/24. Now, what is alleged is conclusory statements that 42 North had possession and control of the property on that date. However, there were no facts that actually, how did they exercise control? What is it about their relationship that exercised control other than the contract? It seems when you look at the complaint allegations that what they're really saying is because there was a contract entered into to perform snow and ice removal, that automatically means that they had possession and control of the property. But that's not a factual allegation sufficient to show possession and control. What it is a legal allegation. And that legal allegation is contradicted by the actual contract that's in existence, which says that salting has to be approved by Carolina. That means that Carolina has exercised control over the property because they can even exclude 42 North from even being on the property. If 42 North goes there and tries to salt without their consent, they can say, no, we didn't approve this, get off. So there is no facts that have been alleged that establish that 42 North actually had possession and control of the property. I guess just turning to a couple other points that were raised in plaintiff's response, there seems to be an argument that Carolina delegated their statutory duties to the defendant 42 North. I think the law is pretty clear that you can't delegate a statutory duty that would be in violation of public policy. Here, the legislature has clearly spoken under MCL 554.139 that the duty of an apartment complex is to maintain the premises in a condition that's fit for its intended use. They didn't say that can be delegated to a contractor to do that. And the prime reason for that is because it's the person who owns the property who is actually in the better position to determine whether that what needs to be done with regard to that property. And finally, I'll just briefly address this. I don't really think it needs to be addressed, but just for record purposes, there was an argument that this motion was untimely filed. MCR two, they cited MCR 2.116B1, that only.
2.116.
B1, that rule only applies when a plaintiff moves for immediate summary disposition upon filing a complaint, not when a defendant files a motion. I'd be happy to entertain any questions the court has, but for these reasons, the defendant believes that as a matter of law, it's entitled to summary disposition as to the plaintiff's claims.
Thank you.
Your Honor, do you want me or plaintiff to go first?
Probably you.
Thank you, Your Honor. Once again, Your Honor, Justin Gonzalez on behalf of Carolina Apartments. Your Honor, as far as our response, we believe that one, that 42 North did have an obligation to plow under the contract. I understand that right now we have disagreements on the contract language, but it says that plowing and salting will be done within 24 hours of the snowfall ending. Plowing and sidewalk, all areas where curb.
Okay. Can you start that again, what it says?
Yeah, so it says plowing and salting will be done within 24, and that's the number 24, hours of the snowfall ending. Plowing and sidewalk clearing will occur when there is more than 2 inches of snow. And Your Honor, we do have that issue with the contract language where we do disagree. Your Honor, my whole point for, at least for this, is that this motion is premature. I think that discovery needs to be conducted. I have, as I've been investigating this case myself, gone to the National Oceanic Atmospheric Administration and pulled the snow records for the date. So this happened on December 21st of 2024. Well, if you look at all these dates, and I can just give these to you, Your Honor, but the day before, there was anywhere from 3, 3.3, 2.5, 3.5, and most importantly, from Lansing, 5.3 inches of snowfall, which means that this clause, which is clause E, would have triggered, and defendant 42 North would have been out there the day before. So their action or their argument is saying that they've had no separate duty. There's no separate duty here. Well, it's premature. We don't know if there was a separate duty or not. We haven't had discovery. We haven't had affidavits done. We haven't had anything done to show whether or not 42 North came out on that day, was requested to come out and didn't come out, whether they did come out and then perhaps create that new risk on which plaintiff fell upon. So I think that this is premature. And as far as, our claim, our cross claim, we believe that there is an indemnification clause. So we'd also ask that they be denied on their motion for summary disposition, because we do have that cross claim.
Well, is there any evidence that the contractor took some action that created a new risk of harm?
Not right now, but this case is new. They haven't responded to our discovery request. That's all we're asking for, Your Honor. We're asking for a time to actually go through and work through this case. Whereas I think that this is entirely premature. We haven't had depositions taken. We haven't even had our discovery responses responded to. They haven't even filed initial disclosures. Now, I understand that they filed a MSD in response to their answer. So whether that's required or not is to Your Honor's discretion. But this is something that I think we really need to work out before we dismiss somebody from the case that could potentially, one, be indemnified, or are we be indemnified from them. They failed to do something and they did create a potential risk. Now, as far as the allegations of negligence, I think that there is a question of fact as to whether or not there was negligence on behalf of 42 North. There was clearly snowfall the day before, which would have enacted them to come out, or at least been contacted to come out. So we haven't had the depositions. We haven't had the discovery from them on whether they came out yet or not. So I would ask that you deny their motion without prejudice. This could be something that happens later, and the motion be filed later once we actually go through the proper procedure and process.
Well, it can also happen that I dismiss them and you still can depose them and do whatever it is you do. And then if you find evidence, or when you find evidence, you bring them back into the case, right?
Well, we do already have a cross claim on the breach of contract. So while you could dismiss the negligence and premises liability claim, we have the claim of breach of contract. And I'd ask that that not be disrupted, if there is a ruling on this motion.
Okay, thank you. Thank you, response?
Yes, thank you, Your Honor. Michael Orla, appearing for the plaintiff. I think where we've gone afield here is that, like, we're talking about a lot of facts here, and this is on the pleadings, right? And I think I raised this, that slew of cases they cited are all C10, right? There hasn't been, yep, are all C10.
Thank you.
Right, they haven't cited a single case where this fact-intensive issue is decided on C8. And really, I think that's what it boils down to, whether it's the question of possession or control, whether it's the question of negligence, even interpreting the Fultz versus Lewicki decisions, all of those are very fact-intensive. And here, I mean, even again, kind of making my argument for me, was this argument interpreting the contract in their reply. How two parties interpreted the contract and what it meant and all of that has to be discoverable, right? They're arguing about contract interpretations, but obviously that isn't pled. We didn't have the contract. And certainly if there's two interpretations about who does what and why, that's fact, I mean, that's fact intensive. So I think just from the get-go, there's not a single case I've seen in their brief and any brief in here that was on the pleadings, on the complaint, decided on C8. And which again, because these are fact-intensive cases, just listening to it, it's a pretty rare instance where there's two defendants kind of pitted against each other on C8, right? That's quite uncommon. And I think that speaks to the prematurity of this motion, and these are fact questions. Now, insofar as the Fultz argument, I think the case law is clear, starting with Lewicki, that there is like exceptions, right? It's not a bright line rule that if they don't create the hazard, there's no liability. Like, I mean, that would be ridiculous if that was the case. And Lewicki clarified that, right? Lewicki kind of reined in Fultz and said, yes, that's one avenue, but you have other avenues under a common law, right? And that's kind of where I think this goes and where the non-delegable duty argument is conflated here, because like under the common law, they have duties. And if that duty is assumed, right, oh, like that was Lewicki, was they assumed a duty, which we do have facts that are pled that lead into that, right? The assumption of duty is triggered from the special relationship between the parties. And I think an argument we made in our response was that they're essentially subcontractors, right? My client is a tenant, she's a contractor of the apartment. The snow and ice company is a contractor of the apartment, and they're equal subcontractors. And obviously that case law is very clear that, you know, contractors and contractees owe duties to each other to keep the premises safe. And starting with that, going into the possession and control, that's another issue that it's fact intensive, right? And, you know, they're citing the terms of the contract as who has possession and control, but without discovery, without taking depositions and seeing what the understanding was, that case law isn't like, you know, it isn't black or white. And the last point that was just raised was the 554-139, and that is, I think, it's very confused here, because yes, if our sole count was 554-139 statutory duties, right, that can't be delegated, right? And we didn't sue the snow company for that duty because it's strictly the landlord. But that's why we have a common law claim for the landlord as well, right? And the Supreme Court case I cited in our response, it's clear that those duties, common law duties, weren't like usurped by 554-139, right? They still run companion. Now, just for kind of the posture here, back prior to Candle El Said.
Yeah, prior to.
You have to Candle El Said. Those premises claims against landlords were routinely dismissed. So 554-139 was your sole avenue. But now that that's changed, right? We have a premises liability and negligence claim against the landlord, and we have an alternative claim for the same essentially allegations against the contractor. And that can be delegated, right? A common law duty, which that's what Lewicki says, right? A common law duty can be delegated, it can be assumed. And those are common law duties. Nothing about 554-139 affects those common law duties between the landlord and the contractor. I think Like, again, it's very fact intensive. And the complaint is specific. In our response, we cited specific allegations regarding each claim. It's not broadly, this is not a claim involving the contract. Yes, the contract is involved because the contractor wouldn't have been there. But aside from that, that doesn't create or change the common law duties that were owed to my client who was a tenant.
And I would agree with you as to the apartment complex, but 42 North is different, isn't it?
I think at this posture, it's not, right? I think we could be here in 6 months on a C10, and I think if the evidence bolsters as 42 North is claiming, then probably, right? But clearly from the landlord's arguments here, right, they believe that the contractor is liable. And I mean, again, I can't know without discovery, right? I have the facts as pled. But so I don't disagree they're different, but I also disagree that the duties owed are any different at this posture.
Okay, thank you.
Yeah, thank you.
Yes, so first of all, it is black letter law. The duty itself is a question of law. And that's what we're here about today. We're here on a duty question that Fultz said a duty cannot exist unless there is some duty separate and distinct from the contractual allegations. That's an issue of law. That's not an issue of fact. And there's black letter law that questions of law are questions of duty or questions of law, and also contract interpretation. There's also a case law that says that's a question of law for the court and not a question of duty. And in fact, in the Lewecki case, I think one thing that's interesting to point out is that it relied and impliedly adopted a Sixth Circuit case called Davis versus Venture One Construction. And there's some language in there that's particularly important because it's illustrative in the fact that Lewecki relied on this case for its proposition. And this shows that Lewecki didn't really wholeheartedly abandon Fultz and didn't really set forth a new requirement. It basically said, no duty to maintain a reasonably safe parking lot of the lot owner to third parties is necessarily assumed by the contractor following the creation of a contract. No duty to perform the contract exists between the contractor and the third party following the creation of a contract. No duty of due care of the contractor to the third party bystander exists prior to or following the creation of the contract. However, when the snowplow driver gets on his plow and performs the contract, he has a duty to perform it with due care towards third parties. This illustrates the point that it's not simply the creation of the contract that assumes that duty of care. And that's what plaintiff seems to be arguing, is that they assumed a duty by entering into this contract, therefore Lewecki applies. That's not the law. Rather, had they actually undertaken some activity on the day in question that created a hazard, then arguably there's a problem. Then there's a duty separate and distinct from the contractual obligations. That's not what's pled here. What's pled here is a failure to salt or ice completely. Therefore, under Fultz and Lewecki, defendants entitled to summary disposition as a matter of law.
As to negligence and premises.
Correct. And I would say, I would agree with co-defense counsel that co-defendant pled a separate theory in their cross claim. They didn't plead premises or negligence, they pled breach of contract. I would agree with co-defendant that probably cannot be dismissed on C8 at this point because their theory is different. But I think as a matter of law under Fultz and Lewecki, the negligence and premises liability claims should be dismissed as a matter of law under C8.
I'm dismissing under C8 the negligence and premises liability, however, without prejudice. I think it's premature to even bring those. There's not a scintilla of evidence that I've heard that a new risk was created of harm. And clearly, this particular defendant was not the possessor of the land. So unless something changes and you have full discovery, regardless of whether that claim is in or out, these can allow both sides to amend But your motion is granted, however, your client's not fully out.
All right, thank you. And so just to clarify,
And
I
you'll
mean,
prepare the order.
okay, will do.
Did you want to clarify something?
No, because I did initially, but in hindsight, I thought better of it because I never asked to have the cross claim dismissed, so I don't think there's any
You
need
didn't,
to.
and I'm not
Right,
doing it,
okay.
so.
And that, right.
Even if you asked, I'm not doing it, okay? So the case is still alive, and it may change as you move forward with discovery, but anticipatory issues, I'm not dealing with that. Give me some reality, and I'm happy to change my ruling. You all have full discovery. This ruling doesn't change that, so come back when you know more.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, that's all. Nice job at the briefing, everybody.
Thanks.
Let's go back till 2:30. Last one's not till 2:30. Maybe.
Which one is that? Which one is it?
It's
I know.
No, I think it's not that way. I was. Right now. No, it's not that bad. No. What reason did you give?
Yes.
Pre-trial form on Java Approach. Yeah.
I have a couple.
He was logged on to Zoom this whole time. Yeah.
Also an MRI. That was one of them as well.
I called and. I have a plan
You guys. Nice day.
Yeah, this is a place I've never been to.
Oh, wow.
So you do want.
Right. Not yet.
When I had a failure.
That sounds good. Let's talk.
Also, I got the amount, like.
It will be.
Like, it's
It's because it's only was.
We went to Corn Fields.
I don't remember what they said.
I'm a dentist. I can't show you what's on this.
My braces are up there.
I had them twice, and then the last time it went for extra 3 years. And then
They
they
just-
ordered on this one. It's close enough.
It was
for
I thought-
emotion. That's what I had.
I thought
Oh.
the interlocutory appeal
Oh.
on the issue of.
Yeah. I'll be up.
Then I-
I have a
Well,
permanent
see,
retainer, but
I
I don't
don't-
barely want to have
Yeah,
one.
I mean, you know, 80% by statistics.
Yeah, I know.
I thought there was nothing we should
Yeah.
try it, and we denied it.
Okay.
Brian, do you need? It's just.
Yeah, I need some copies. I need the original for him.
Nicole.
Yeah.
We'll go back there. Yeah.
Sure.
All you
Thanks so much.
and two ladies. Well, this is an old case.
Is everybody here on Kyla Homes versus MDOC?
Good afternoon, just me so far, Your Honor. Mandela Johnson on behalf of defendants. Ones that remain.
We'll wait, we're just a little early today, unusually, so.
Do you mind if I take a seat at council?
Oh, have fun. Huh?
Yes.
Well, this has been just a fun day. Are we done with criminal?
Yeah.
For the homeless encampment.
No, there we go. Already been done.
Yeah.
All right, good.
This is docket 25-3481 CD, Kyla Holmes versus Michigan Department of Corrections, Hattie Washington in her individual capacity, and Christopher Gotts in his individual capacity, Robert McGeorge in his individual capacity, and Kyle Kaminsky in his individual capacity. Counsel, your appearances for the record.
Good afternoon, Your Honor. Zach Runyon on behalf of plaintiff. Good afternoon, Your Honor. Ken Ellis Henson on behalf of defendants MDOC, Heidi Washington, Robert McGeorge, and Kyle Kaminsky only.
Thank you. This is defendant Michigan Department of Corrections motion for summary disposition. You may proceed.
Thank you, Your Honor.
So you represent everybody how except for Gauss?
Gauss, correct.
Does he have just an attorney in his file? Are we waiting for another attorney?
I don't believe so. I believe the case, if memory serves, it was stayed as to him based on a bankruptcy stay. That's correct, Judge.
Okay. Okay. Thank you.
So good afternoon, Your Honor. I do not represent Mr. Gauss, and if the allegations against him are true, then his behavior was repugnant and antithetical to the high standard that we expect from state.
Hold on, his behavior was repugnant and what?
Antithetical to the high standard of conduct that we expect from state employees. In Christie versus Wayne State University, the Michigan Supreme Court held that all parties suing the state or an arm of the state must comply with the notice provision of the Court of Claims Act. I could have saved a little bit of space in my brief by just talking about the 1 year requirement, because as of right now, it appears as though the events that were closest in time to when the notice of intent, which is required under the Court of Claims to be filed, were within 18 months. And so whether the standard is 6 months or 1 year under the Court of Claims Act, it's really an academic matter for this particular case. All of the alleged adverse actions were more than 1 year prior to the filing of the notice of intent. And so the Michigan Department of Corrections, based on binding Supreme Court precedent and the binding Supreme Court precedent, must be dismissed. The case of Christie, as plaintiffs concede in footnote 1, is binding on all pending cases according to the Court of Appeals published opinion in Hudson. I think here today, the real dispute is between whether or not Director Washington, Robert George, and Kyle Kaminsky were sued in their individual or official capacities. And I think the question that the Court of Appeals has set forth in City of Mount Pleasant really is instructive here. That was a case involving claims against the director of the Department of Management and Budget, as well as Attorney General Dana Nessel. And I just want to correct something. In my initial brief, I said that suit was filed in individual capacity. I believe it was in fact official capacity. I tried to correct that in my reply to that. Just wanted to point that out. So in City of Mount Pleasant, though, the Court of Appeals in this published decision said that the question was whether or not the suit is against the state official in his or her official capacity such that it is a suit against the state's office. And so that's really what the question is. Is this particular suit really a suit against the office that these individuals held with the Department of Corrections? And it's defendant's contention that yes, it is. All of the conduct that they are alleged to have engaged in was official capacity conduct. With regard to Director Washington and Mr. Kaminsky, the only allegation is an alleged failure to take action. And the only obligation that they would have to act is based on their official capacity. With regard to Mr. McGeorge, there's one allegation against Mr. McGeorge, and there's kind of an attempt to kind of lump together Mr. McGeorge's conduct with Mr. Gauss, which has no connection. Mr. McGeorge is alleged on one single occasion to have made a stray remark where he allegedly called his daughter's new roommate a word that starts with a W, but it's not woman. And then the plaintiff asked him to repeat this. And that's the one allegation against Mr. McGeorge. That does not
That's
rise
the one allegation, what?
against Mr. McGeorge. Excuse me, I apologize, I'm talking a little bit fast. That's the single allegation against Mr. McGeorge, and that does not rise to the level of a severe or pervasive hostile work environment. And so inasmuch as Kyle Kaminsky is alleged to have had information about that interaction between Mr. McGeorge and plaintiff, that does not rise to the level of severe and pervasive hostile work environment is one comment. And there must be some kind of showing of a reoccurring problem or a repetition of an offense that was likely to occur. And we just don't have that in this case. These comments were alleged to have taken place in 2022. And there's nothing else in this complaint of any allegations against Mr. McGeorge. And so what we have here today is while the caption is titled individual capacity, what's really going on here is a suit against the state, against these individuals in their official capacity, despite what the caption says. And if we look at 6431, the notice provision of the Court of Claims Act, we see that this kind of lawsuit is exactly what that provision covers. There must be a notice of intent filed against the state before any lawsuit can commence against the state or any of the state's arms, which these individuals would be an arm of the state. They're acting as agents of the state in this capacity. If the court has any questions, I'm happy to address those. Otherwise, I'll reserve whatever time I have left for.
Thank you. Response? Tell me about the 1-year look back. Why should I keep this alive?
Thank you, Judge. The reason is because in Pike, the Court of Appeals expressly stated that the notice provision in the Court of Claims Act does not apply to individuals. It only applies to the state of Michigan. And so the claims against the individual defendants, we were not required to file a notice of intent for. And so the way that the defendants are trying to get around this is to say that the suit we brought is actually against the defendants in their official rather than their individual capacity. And that's just not true. What the defendant said is the test for official versus individual capacity is inaccurate. That is the result of it. The result of suing someone in their official capacity means that you're bringing the suit against the office rather than the individual. But the real test is, especially at this stage, it's just who is the plaintiff attempting to sue? Is it the individual in their individual capacity, meaning that if we get a judgment, we have to collect it from the individual defendant? Or are they trying to sue the state of Michigan? And if they succeed against the individual, try to collect from the state of Michigan. And if you look at the way it's been defined in Michigan courts, that's really the distinction, is who would be liable to pay the judgment. Would it be the individual or the state of Michigan? And what defendants have done is they've really conflated the idea of individual capacity and official capacity with scope of employment. And most of these questions have been answered in federal cases because this generally arises in 1983 cases. And if you look at the Supreme Court opinion in Haffer v. Mello, they really tackle this issue head on. And they say that a suit against an individual defendant does not become an official capacity suit just because the actions alleged occurred within the scope of their employment. And what they say is that would essentially make every civil rights case an official capacity case because almost every time these suits are brought, the individual is acting within the scope of their employment. And so the test, it really has nothing to do with whether or not these actions occurred while the individual defendants were at work. The question is, can plaintiff maintain suits against these individuals for violations of the Elliott-Larsen Act? Which we can, and I cited the Elizovich case in from Michigan Supreme Court, which says that individuals can be liable for violations of the Elliott-Larsen Act. And so
I don't want to spend all day up here talking about my complaint, but for McGeorge specifically, I have filed as an exhibit, a proposed amended complaint that would provide more allegations against McGeorge specifically. And what it would really do, I think, is certainly get past the notice pleading standard for the retaliation claim against McGeorge. As far as whether or not, we can maintain a hostile work environment claim against McGeorge, I think it's way too early to decide that. Because the question isn't, is it repetitive? The question is, did work environment become hostile or affect the terms and conditions of plaintiff's employment? And that's a factual issue, something that would be developed in discovery. As for Kaminsky, the amended complaint also adds allegations that show you have a retaliation claim against him, specifically related to how he handled plaintiff's complaint that McGeorge was sexually harassing her. Among other things, he dissuaded her from bringing the complaint to Human Resources or Internal Affairs. He then told McGeorge about my client's complaint, which resulted in McGeorge retaliating against my client even further. And then when my client went to Kyle Kaminsky and asked him, can you please remove me because McGeorge is creating a hostile work environment, he refused. And so I think certainly those allegations get us past the notice pleading standard in
Hold
Michigan.
on. I certainly think those allegations went.
Get us past the notice pleading standard. And summary disposition on those claims would be inappropriate at this juncture. As for Heidi Washington, the proposed amendment complaint also provides a factual basis to show that we've at least provided sufficient notice of the claim that we're pursuing, which is that she was Gautz's direct supervisor. Based on the pervasiveness of Gautz's behavior, she either knew or should have known it was occurring and was responsible for taking remedial action to stop the sexual harassment. And I think it's important to keep in mind that this is not the only lawsuit arising out of Chris Gautz sexually harassing his female coworkers. There's another case right now in Wayne County Circuit Court by a female Lisa Gass who makes similar allegations. And it's important to note that the Wayne County Circuit Court just denied defendant's motion on the same grounds. And we know of at least one other female that Christopher Gautz was doing this to around the same time frame. So we have at least 3 women that he was sexually harassing, which I think provides again, for this stage at least, a sufficient basis to say that we've stated a claim against Heidi Washington based on her failure to take prompt and remedial action. So for those reasons, I would ask that the motion be denied. As to the individuals, as to the claims against the department, I agree that given the Hudson case, it is applied retroactively, but I know that there's a current appeal with the Michigan Supreme Court for them to review whether or not Christie should be applied retroactively. There's been, the Hudson decision was actually I see you nodding your head, so I'm sure you already know this, but it was a conflict panel because there had been competing Court of Appeals decisions and.
Not unusual for them these days.
Exactly. And while true, one of the concurring opinions said that, this needs to be looked at by the Michigan Supreme Court. And so I just had to preserve that issue for appeal because I think if you look at the factors, it should not be applied retroactively, but I understand that's the current state of the law right now.
Thank you.
Thank you.
Response?
I'll first respond by talking a little bit about Pike. Pike was decided before Christie, and it involved, the facts of that case were an instructor at, I believe it was Northern Michigan University, had some students blindfolded and without safety equipment climbing a rock wall, which was clearly beyond the scope of his employment. And so in that case, there wasn't the same kind of scope of employment analysis that is present here and is relevant to the Mount Pleasant analysis. And I think Mount Pleasant really is controlling here. And so all of the different allegations, again, against Director Washington, it's that she failed to use state resources to conduct an investigation or whatever the allegation is that she should have done. You know, and the same goes for Kyle Kaminsky. The only more additional allegations that I saw in the amended complaint were some allegations of rudeness. Rudeness. I don't recall seeing any particular details surrounding that. And so to me, it seems to fall in the same category. And the notion that Kyle Kaminsky talked with McGeorge about the complaint actually, I think, cuts against the plaintiff's argument, because that demonstrates a prompt remedial measure, because there were no additional comments along those lines ever made to the plaintiff again. And so what I think we have here are claims against these individuals really in their official capacity for allegedly failing to take actions that they were allegedly supposed to take on behalf of the state. I think there's a pretty big difference between the federal case law on individual capacity and the state case law. And the reason for that is really the 11th Amendment. The 11th Amendment.
Thank you.
There has to be, under a 1983 claim, a way to sue state individuals, because the 11th Amendment prohibits states from being sued under 1983. Here we don't have that same prohibition. The state can be sued under the Elliott-Larsen Civil Rights Act. You just have to follow the procedures that are set forth in the notice provision of the Court of Claims Act. And here, plaintiff is simply attempting to circumvent that requirement, because were it not for the notice provision, plaintiff would be attempting to sue MDOC directly. I don't think they want whatever is in Kyle Kaminsky's pockets or whatever is in Mr. McGeorge or even the director's pockets at this point. And so this is simply an attempt to circumvent the notice requirement that the state legislature put into law and that the Supreme Court has held is required before you sue the state. So it's simply an attempt to circumvent that. There can be individual liability under Elizovic versus Bennett, absolutely. However, it's for individual conduct. Mr. Gouts, potentially, plaintiff could have a lawsuit against Mr. Gouts. What Mr. Gouts did was completely outside of, as alleged, I'm not taking a position on that, but as alleged, would be completely outside of any kind of official conduct. And it's more than just an argument that this was behavior that they engaged in at work. It is, were they being alleged to have not used state authority in their official capacity? And clearly, as to Kaminsky and Director Washington, that is the case. And again, with regard to McGeorge, the really only allegation against him is that one comment. The others are just, allegations without any direct connection to an Elliott-Larsen civil rights claim. And unless the court has any further questions, I think I'll rely on the briefs.
Have you, let me just ask, you've seen his amended complaint?
I believe it was attached to the pleadings. I read through it.
But you haven't responded to them yet?
I have not responded to a complaint.
But what you responded to before me was that it doesn't matter because they're still under the guise of their employment, everything that was asserted.
Correct. That it would be futile to allow the amendment, because the amendment was attached to the response to my motion as a proposed amendment.
Under the 1-year look back rule, whether you agree with it or not, that is the state that we're dealing with. Clearly, Court of Appeals and Supreme Court have some work to do in a lot of areas to get their rulings together, because this is not the only case I have where there's 2 different opinions on the same kind of case. But nonetheless, the look back rule is what I'm going to rely on, and certainly that was not met. I also, based on what I've read, do think that these were not in the individual capacity, but rather the conduct was in the official capacity. The there's a violation of the 1-year look back rules, so I am going to grant defendant's motion in regard to all of your clients. I guess Mr. Gouts, if he's got a bankruptcy, then there's a stay there. I don't know where that's necessarily going to leave us, but that would be under a stay, and certainly you are all free to appeal me or do a motion for reconsideration, but as far as I'm concerned, this case is closed. You'll prepare the order?
Yes, Your Honor. Would you like this afternoon or submitted?
You can do it under the 7 days.
Thank you, Your Honor.
No problem.